At heto na nga, no, ngayong araw na ito, Lunes, no, magpapatuloy po ang impeachment trial ni Vice President Inday Sara Duterte. At yan po ang aabangan natin mamaya. Pero bago natin yan na papanoorin, ay kilalanin muna natin ang defense team ni Vice President Inday Sara Duterte. At bago natin saksihan yung impeachment trial, ay atin ring pakikinggan itong itong part sa defense team ni VP Sara na itong si Attorney Michael Powa kung ano ang mangyayari ngayon sa impeachment trial ni VP Sara. Ano ang ganap? Okay? Atin pong pakikinggan po itong si Attorney Powa. Okay? So, yun lang po ang ating re-reactionan ngayon. Okay? Bahalaga po na malaman natin detail by detail itong impeachment trial ni VP Sara ngayong week na ito. Okay? Paki-like muna, paki-share itong ating video para guys kakalat ito sa taong bayan. At sa mga hindi pa nakasubscribe dito sa ating channel, mag-subscribe na po kayo. Kasi libre lang naman talaga ang mag-subscribe sa YouTube, walang bayad yan. Updated pa kayo sa ating mga trending na mga balita. Okay? Kailangan natin marinig ito bago simulan ang impeachment. Ito.
What was the nature of that visit? Why was it important for her to come to the Senate ahead of her actual day of trial?
Well, to be honest, Katrina, kami sa defense, we never really had any communication with Yusek Lopez or the OVP. That's why when she was there yesterday as part of my preparations for probably the round of interviews that I'll be doing, I just simply asked the staff kung ano yung purpose. And I was told the purpose was really administrative by nature. For example, not long ago, I got a message from OVP asking if we could accommodate, I think, the OVP media beat inside the Senate. So I said, that's not something that falls within our responsibility, because I understand that there are sort of teams formed to cover the defense, the prosecution, and the trial itself. So perhaps those were one of those things, na administrative, that they went there for. And also, as you know, the defense and the prosecution also are given allotted seats. I think around 45 seats for the defense and 45 seats for the prosecution, and 61 for the public. So I was asked if there are times that OVP personnel would like to also visit and view the proceedings. So I said yes, but perhaps a necessary request would have to be made. And so perhaps those are also one of those things that they spoke about. But I don't want to speculate on whatever went on in the meeting, because again, I wasn't present and I wasn't made aware directly.
So even on a personal capacity, the defense panel is not actually directly involved in the witness rep of Zuleika Lopez?
No, because she's not our witness as of the moment. The subpoena was requested for by the prosecution, not the defense. So sa amin, what we are preparing for is really cross-examining her once she takes the stand. Or we'll have to look at the purpose of the testimony for which she was being asked to take the stand by the prosecution, and that would be the appropriate time for the defense to register any objections if there are any. So I'm not saying we will be. I'm just saying that it will depend on whatever purpose they will be stating.
Right. I understand that you seem to not believe that it's not actually fit or necessary to discuss strategy as well as matters of the trial or details of the trial itself. But as far as the defense team is concerned, how different is the preparation when it comes to prepping a regular witness, your witness, as well as someone who is already marked as a hostile witness for the prosecution?
Well, definitely there's a huge difference in terms of the rules. For example, we're talking in general terms, diba? Once a witness is qualified as a hostile witness for the party calling such witness, nag-iiba kasi yung rules eh. Usually on direct examination, you can not ask leading questions on the witness that you call to the stand. But once the witness is then qualified as a hostile witness, then, for example, in this case, the prosecution can now start asking leading questions. What are leading questions? Meaning questions that are answerable by simply yes or no. So, in terms of the preparation of the defense, knowing that that could be a possibility, a very real possibility, syempre, we are also now focusing on our strategy naman when it's our turn to cross-examine the witness, because then the dynamics would change.
And how difficult is it, considering that Attorney Lopez has already been summoned in the House of Representatives, as your camp quotes it, mini trial? Do you feel that the questions that will be asked during the actual trial would be quite similar already to those that have already been asked during the House proceedings?
Actually, just to clarify and just to be fair to also the House of Representatives, what was coined initially as a mini trial, subject to the explanation made by the lead prosecutor now, Representative Luistro, was the proceedings held in the Committee on Justice. Hindi naman napatawag si Attorney Zuleika doon. In fact, I was the one na napatawag doon. I believe Attorney Zuleika's invite to attend the hearings came during the good government and public accountability
All right,
committee
so
hearings.
it's not an all-encompassing term with regard to the proceedings that happened in the House.
No, yeah, we were the mini trial was really confined to the Committee on Justice hearings, no. So at least, well, that gives us a fair idea kung ano yung mga issues that will be brought out, in terms of her appearance. But again, we cannot be too confident na malilimit lang doon, especially since we're talking about Article 4 now, no, which yun yung nauna kasi yung grave threats. So based on that, syempre, the job of the defense is to anticipate whatever may be asked and then to prepare for them. Yun lang naman ang pwede namin gawin sa ngayon.
I know you have already briefly answered this question during the post-trial press conference last Wednesday, but why was it important for the defense to actually show or flash a clip of Attorney Lopez's so-called meltdown or very emotional moment during that Zoom meeting sometime in November 2024?
Well, Katrina, to be honest, it's very hard for me to answer those questions because I'm very mindful of the rules on discussing merits, but perhaps I could just say, para lang maintindihan ng taong bayan without getting into the merits on whether we were successful or not, no? It's really, we needed to show context, diba? Because there were clips that were shown on specific things that the Vice President said, so we had to show other clips to show the context. But whether that was taken as contextual already is something up to the impeachment court, and it's not something that I can honestly argue through media interviews, because then that would be in violation of the rules.
Well, since you mentioned context, Attorney CJ Narvasa was quite intent on actually playing the entire more than 2-hour long video on Tuesday, on the second day of the impeachment trial. But then there was a sort of withdrawal of that motion or that insinuation come Wednesday. Talk to us about the wisdom behind that pivot. Why did the defense suddenly shift its strategy of wanting to play the video for an entire 2 hours to simply just playing clips of that video?
Well, to be very candid, we haven't really shifted on the strategy just yet, no? Everything naman that is done by the person on deck is always a strategy, not of the person, but of the entire team. Now, at that point, we did not feel that it was necessary yet to play the entire 2-hour, 26-minute clip.
So there's still a chance that we will be watching?
Yes, there is still a chance. I'm not discounting that possibility. No, I'm not saying we will definitely do it, but I'm also discounting the possibility that we will, because again, it's very important to get the context of the matter, no, in terms of grave threat, no. Itong pinag-uusapan natin kung ano ba talaga bang may pagbabanta, at kung hindi yun pagbabanta, paano tayo dumating sa ganung utterances, hindi ba? So very important yung context. So sa ngayon, nung nangyari nung Wednesday, I think it was day 3 of the trial, we felt at that time that there was no necessity really to play the 2-hour clip, because obviously, as we all know, 2-hour 26 minutes, that takes a lot of time, not just the time of the parties, but especially the time of the impeachment court, no? So that takes up judicial time. So once we do it, we want to make sure that it is definitely necessary for our defense to play that before we subject the senators to a 2-hour 26-minute clip.
Do you feel that that strategy would not backfire from your end? Because critics of the Vice President would definitely say that the defense is trying to dribble the ball game here.
No, it's not really dribbling. It will depend on the nature kasi of the testimony of the witnesses that the prosecution will be presenting. So in terms of the witness that was presented the other day, kay Agent Kalilong, we felt that it wasn't really necessary just yet. But that doesn't mean that we won't insist on playing the video for some other witness which we think would be vital for that witness.
Also, during the post-trial press conference on Wednesday, you gave Attorney CJ Narvasa a 10 out of 10 score in terms of performance, despite the backlash that he got from social media on the second day. Talk to us about that rating. What's behind that number?
Just to clarify, actually the question was, one media personnel there asked that the prosecution gave itself a 10 out of 10. No? So asked me what I thought about the defense, not particularly Attorney Narvasa, but the defense as a whole. So I said, well, to be honest, sa tingin ko 10 out of 10 rin. Why? Because we hit our targets, no, for the first week of trial. But as to Attorney CJ, I would like to also thank him for what he did, no, for his performance. Regardless of people, there will always be, since it's such a divisive issue and it is a politically charged trial, there will always be bashers and there will always be people who might like what we're doing. So sa atin, that's par for the course, diba? So, but sa amin, we had our targets for Attorney CJ to deliver, and at least in our view, he was able to deliver those targets. Now, if there are people who didn't like that, I think that comes with the job, really.
Before we talk about those specific targets, at least those that were already discussed in court already, did some senior members of the defense panel at least gave a tip, not really reprimand, but maybe advised Attorney Narvasa to perhaps limit some of the objections, because there were some points where even the date of the video itself, he was already objecting to that point? Well,
Attorney Narvasa, is an experienced lawyer, so of course everything we do in court no, is discussed even prior to before we even enter the impeachment court. So to be honest, Attorney Narvasa was just doing his job as a lawyer. You know, there were a lot of things online saying about, you know, Mr. Objection. That's, you know, I don't, that's the elephant in the room, no? People were saying Mr. Objection, etc. But the next day, Attorney Ligutan was also registering a lot of objections, you know. But again, there's nothing wrong with what Attorney Ligutan did. There's nothing wrong with what we feel, with what Attorney CJ did. Lawyers really need to object to protect the rights of our client once the ground for objection becomes apparent. And when is that? When the question is asked. No? So sa amin, kasi if we don't object, then we waive the objection that matters. So wala namang naging parang advice or reprimand. I think we all know what we're doing here. Of course, there are strategies that we discuss within the group, no, that I cannot disclose. But definitely, we feel that the first week went as the way we expected it to go, and yun nga, no, without, I cannot of course discuss the specific targets, but we made our targets.
Frankly speaking, Attorney Po, I think the sentiment, especially online, was not just about the quantity of objections, but the quality of objections. Next week, should we still expect a lot of objections coming from the side of the defense, especially as the prosecution presents Agent Lotok as well as Attorney Zuleika Lopez?
I cannot say for sure because again, objections will depend on the questions propounded by the opposing side, no? So it will really depend on the prosecution. Kung sa tingin namin na yung question nila is objectionable, we will definitely object. Now, as to quality, I think that's a bit subjective, so I will probably not comment on that. But you know, there are different styles for different lawyers, and we'll see how the proceedings go this week. But rest assured that kung wala namang basehan yung objection, hindi naman siguro kami mag-object para lang manggulo.
Is there a conscious effort on the part of the defense to stay off of social media, at least while the trial is ongoing?
To be honest, that would have been a privilege, which it is a privilege I don't have, because as you know, also aside from being counsel and taking on some of course, the legal arguments and being part of the team, I also have to be spokesperson, and I cannot be spokesperson if I do not have somewhat of a scan, no, of what's going on in social media. So yes, as much as possible, we'd like to sort of block out the noise muna and just focus on the job. But as far as I'm concerned, I cannot get away from it. Diba? So,
you're still not yet in the direct line of fire so far. Will you be cross-examining a witness?
I'm sure at some point, I will be in the direct line of fire. Diba? Parang, ano lang yan eh, whoever is on deck, diba, is always on the direct line of fire. So yes, so of course, I will have my turn, no, at some point. And when that happens, I'm sure I will also be subjected to bashing on one end and maybe people supporting another end. But again, it's par for the course. It's part of our job. And siguro, kailangan lang namin talaga to get ourselves, no, to just focus on our work rather than the noise all around.
All right, let's talk about the targets that you mentioned. You earlier said that you were quite satisfied with the performance of Attorney CJ Narvasa because he delivered some of the targets that you have set for him. What are these targets?
We cannot
At least those that were already discussed on the floor.
Because it will go into merits. But at least we wanted to test the credibility, obviously, of the witness. We also wanted to show the nature of itong affidavit of investigation, di ba, na lumabas naman factual lang, na dalawa yung naging affidavit of investigation, etc. So, ano pang tayo naman eh, we're early days in the trial, no? So, we're trying to establish certain facts with certain witnesses, and then, of course, there will be more witnesses to come, and we will try to do the same.
Right. So, it's no secret to the public that the main goal of the defense at this point was to debunk the credibility of Agent Mark Calilong.
Well, not just the credibility. That's always part kasi of every cross-examination, syempre. Not just debunk the credibility, but at least test the credibility. Because, of course, if you test the credibility, it will also go into the credibility of what he or she is saying, diba, in court. But again, I'll leave it at that, Katrina. You're putting me in a very, I'm skirting contempt every question. So I'd rather,
I'm trying my luck to fish
if you
out all
still
the
want
answers.
to see me during the trial, then perhaps we can then I should be more cautious about things.
All right, let's talk about, I know you don't want to talk about this, but I have to push. Let's talk about Senator Judge Risa Ontiveros' statement that she questioned, or I'm sure it was, I think it was her, but it might be another Senator Judge if my memory fails me. There was a Senator Judge who mentioned, or who questioned, na enough justification ba na may alleged threat issued against the Vice President for her to engage or blurt out that kind of rhetoric that she said against the President. Do you feel that that has already earned earned some points for the prosecution, considering that it's public sentiment. It's a common public sentiment.
Well, sa akin, no, of course, with all due respect to the senator judges, they are free to ask kasi whatever questions at, and it is up to the presiding officer to decide if something is out of order or not. So kami naman, we have to submit ourselves to the court. So pag nagtanong ang senator judge, we just have to respond. But I think it's early days. That's not the only theory that we have on the case naman. So as to points, if the prosecution feels like they earned points there, then by all means, they're free to feel as such or consider such. But sa amin, hindi pa naman, masyado pang maaga. No? So we still have a lot of witnesses to be presented by the prosecution in the coming days. And then, of course, it will be our turn, no? At some point, once the prosecution is done with their presentation, then it will be our it will be our turn to now present our own witnesses, and perhaps you will be able to see the entire defense once we do that.
Let me ask you point blank. Do you think that it's enough justification that she received a prior threat for her to...
Katrina, sorry, I understand why you're doing this, but I cannot answer that right
I tried. At least I tried. All right. Speaking of next week's trial, let's try to push the story forward. The prosecution earlier mentioned that they chose the fourth article of impeachment as the first matter to be discussed because for them it was the easiest to actually lay out before the public. Does the defense feel the same way about the fourth article of impeachment being the first to be presented in the public?
Wala kaming sa amin kasi we treat each article with guarded confidence, meaning we're confident that we have a solid defense for each article. But again, guarded, why? Because still, you can never be overconfident about things, and you always have to prepare for each article. Now, when it comes to grave threat being the first article to be tackled, and that's what they're doing now, sa amin, that's well within the prerogative of the prosecution. That's why, if you notice, we never even objected to the order of trial that they wanted, because nasa kanila naman yan. And me, I'm always trying to be as objective as possible, no, para sa kaalaman din ng ating mga kababayan. Yan po ay yung desisyon kung ano yung uunahin is really with the prosecution. Now, if they feel that is one of the strongest articles, then by all means, they can do that. Sa amin naman, each article, we really have to be we have to be on our we have to be guarded in a way that we have to make sure that whatever happens, we're able to provide a solid defense for the Vice President para mapatunayan namin sa taong bayan na walang basihan yung mga allegation, no? But again, we'll see how things go.
Right. The prosecution still is pushing the Vice President to attend her own trial, and you have been quite vague in answering that question. I understand you're keeping your options open, but at this point, did the Vice President change her mind, her inclination to whether or not she would attend her trial?
Not yet, kasi hindi pa namin napag-uusapan. Actually, she's never made up a decision as well, no? Because I know it seems vague that I say kung kinakailangan. But
or sometimes you answer kasi I will not say yes, I will not say no.
Yes,
so it's a very open answer.
Because that's the truth. At this point, hindi pa namin alam kung kinakailangan o hindi. It will really... perhaps you might think it's intentionally vague, but yun talaga yung totoo.
So it's not strategy?
It's really not strategy, because when we talk about strategy, it's more of alam mo na kung kailan mo siya ilalabas, diba? Pero sa ngayon, hindi pa talaga namin na-determine kasi it will really depend kung ano yung takbo ng proceedings. Kung hindi naman kinakailangan, and we don't think it will give us an advantage to do so, or it will not be advantageous for us to do so, then why subject the Vice President to something like that? Now, pag kung kinakailangan talaga, then that is something for us to advise our client, which is the Vice President, and ultimately it will be her decision, no? But she's, just to clarify matters, she's never said no to the possibility of being there, and she's never said yes to the possibility of being there kasi nga too early pa para pag-usapan sa ngayon.
Yung prosecution, one of the usual lines of narrative that they have been saying is that the Vice President seemed to not be taking, not a verbatim quote from them, but they're saying that the Vice President seems to not be taking her impeachment trial so seriously because she has refused to attend.
I've heard that, but
yung tanong na yan, kung seryoso ba si Pipi Sara dito sa impeachment, hindi niya siniseryoso in the sense na sa tingin siguro ni Pipi Sara, useless itong oras na ito. Kasi walang basihan pamumulitika. Useless in the sense na pamumulitika. Pero, kung paano niya ito dinedepensahan, sobra pa sa serious. Yung patungkol, tingnan nyo yung defense team ni Pipi Sara ngayon. Sobrang matibay. So, talagang pinagtuunan niya ito ng pansin na hindi siya basta-basta ninyo matitibag.
I don't think attendance equates to how seriously she's taking the impeachment trial. In fact, if she wasn't taking this seriously, she wouldn't even have spent the time to form or to choose the defense team, to have us participate in the defense team, to talk to us, to communicate with me, for example, on a daily basis. So I can say for sure that she is taking this seriously, but at the same time, she is also taking her job and mandate as a Vice President seriously. And that is why, she formed us early properly, so that even with the impeachment trial ongoing, she is not neglecting her duties as a vice president as well.
I understand that she has been in constant communication with you, but with regard to communicating with the entire defense team, how often does the vice president do that? Will we get to see her again in the Senate in the coming weeks?
Well, we don't, we do things even outside the Senate. It's just that the other day, so there's always constant communication naman between us, but I mean between the team and her. But what happened last Tuesday, if I'm not mistaken, no, was really because there was time. She had time in her schedule to at least meet with us, and since the time frame around 12 o'clock and 1 o'clock, the defense is usually already in the Senate by that time. She decided na doon na lang siya pupunta, because if we were to meet elsewhere and get stuck in traffic, we might not get to the Senate by 2 p.m. So yun lang naman yun. It's really, I know that certain groups have been making a lot out of it, but it's as simple as that. It was really a regular meeting that had to be held where we were, because if not, then we might not have made the 2 p.m. Trial, the commencement of the trial at 2 p.m.
And the decision not to allow the vice president to take questions from the media, is there some leeway to still change that decision? She has been blaming you for that decision.
Yes, she has been blaming me. I will not deny that. I think she pointed out to me during
in front of everybody.
Well, the thing here is, again, the defense is very mindful kasi of Rule 18 of Resolution 39, which is the rules on impeachment. No? And there it's very clear that the parties, which obviously includes the vice president being the respondent, and their counsel and the members of the impeachment court, cannot discuss things publicly. So just being very mindful of that, I advised her that she shouldn't take questions, because obviously at that point questions will really be on the issues being thrown at her in this impeachment trial, and we might venture into the merits. So we don't want to be skirting contempt on a daily basis. So ano lang tayo, no? We're just being careful.
Do you not trust the vice president?
I
She
trust.
knows
Pero yung prosecutors araw-araw nagpapa-press con.
when to draw the line, given that she's a lawyer herself.
I do trust the vice president, but in this case, I felt that it would be best, no, that counsel answer questions.
Less talk, less mistake?
Well, even for myself, that's always been my mantra. That's why sometimes I tell you, hindi ko masasagot yan, di ba? Lalo na if medyo gray area. So, sa akin kasi, I don't wanna complicate things because things are, heavy enough for us.
Okay, so we're losing some time here. We're running out of time, but we would like to continue on. But let's talk about what we should expect in the coming weeks, at least from the side of the defense.
From the side of the defense, obviously at this point, all we can do is really cross-examine, no? And maybe, as you said, object if we feel that the questions are violative of the rules. No? So next week, I think, and we'd like to thank the prosecution for disclosing already their witnesses as agreed. So there will be witnesses from the NBI. Of course, Attorney Lopez will be there, and and I think one of the House security officers, will be there. So I think we will definitely have to test their not just their credibility, but really the testimony that they will be giving. So kami naman, yun lang pinaghahandaan namin. Sa ngayon kasi, wala pa akong masasabi what to expect on the part of the defense aside from that, because it's not yet our turn to present.
Are you
evidence.
privy to disclose kung sino sa defense lawyers would be taking the floor next week?
Right now, we're still looking into it, kung it will be one or two, that will be there. Because the thing here is, when it comes to the defense, we expect all of the lawyers to be prepared to take on any witness at any given day. That's why we're very open about all the materials. We share all the materials. So, tingnan na lang natin kung sino. We still have meetings over the weekend, no? And then we'll see on Monday.
All right. Why was it a conscious decision to let another lawyer actually deliver the closing statement, at least for the first witness?
No, it's just really a distribution of work for us, diba? Kasi syempre, it's a lot of preparation already preparing for a witness. So once there's another task of like closing statement or summation, just because it's something that came up, kasi because the prosecution was allowed some leeway there, and they wanted to be fair. I mean, the impeachment court wanted to be fair and wanted to give us the opportunity. So at that time, since Attorney Nervasa was on deck for the cross-examination, we decided that someone else take the cudgels.
Attorney Vinluan?
Attorney Vinluan take the cudgels naman for that sort of statement that we gave. And it's really part of the teamwork that we do. There's really distribution of work.
Okay, as you saw earlier, some senator judges are quite hoping that the proceedings will somehow be quicker in the coming days. Is that a guarantee? What kind of guarantee can the defense give that it would somehow abbreviate?
Well, I think the only guarantee that we can give is from the very beginning, we never intended to prolong or delay proceedings. And I think to be fair, again, both sides, no, prosecution and defense, wala naman sa amin ang gustong mapahaba to, because pag mapahaba to, kami rin naman yung nakasalang dyan for the X number of months, diba? So sa amin, we're reasonable naman when it comes to things. So if there's any suggestion from the senators, like the other day, we were asked or requested by a senator if we could just simplify matters and things like that. And we're keen to do that, no? But within the bounds. Because right now, the defense cannot really say how many days we will exactly need. Because again, it will depend on what the prosecution will be able to present first. And we'll have to react to what they present. So tingnan muna natin kung ano yung magiging paglatag ng ebidensya ng prosecution. And the defense will try to respond accordingly without unnecessarily delaying the proceedings.
And finally, Attorney Poa, there are some political observers and analysts who have been saying that compared to the Estrada as well as the Corona impeachment trials, I think this is the first time that the defense was given a leeway to a pre-trial proceedings. They say that
the defense and the prosecution, though, just to be fair.
Yeah, but these observers, particularly Ed Montaya, who we had on the show last week, said that this gives the defense a lot of leeway, a lot of advantage. Your comment on that kind of criticism?
I think it's unfair to say that the advantage is only in the part of the defense. The prosecution was also there. Both parties were in the pre-trial. Ano ba nangyari sa pre-trial? We tried to, syempre, meron tayong pre-trial brief na pinapresent natin, stipulation of facts, diba? Sa simplification of the issues, and then we determine the administrative matters, no? And of course, we give a list of our witnesses, pieces of documentary evidence that we intend to present. Ganun din naman yung prosecution. So I think whatever happened there, if there were any benefits, it would have been beneficial for both sides and not just the defense. But aside from that, there were pieces of evidence marked, and there were pieces of evidence that were reserved. Meaning, hindi pa namin sinasabi kung ano yun, hindi pa rin sinasabi ng prosecution kung ano yun, although yung purpose is stated. And pre-trial is always part of not just the impeachment trial, but I mean, this might be the first time that they did it for the impeachment trial, although I'll have to confirm that, no? But in terms of regular proceedings in the regular courts, it's part of the rules. It's actually mandatory to. The point of that is to expedite proceedings para masimplify na lahat. So if there was if it was beneficial, I think it's unfair to say it's just part of the defense.
Right. Since you already mentioned the rule that you are allowed to reserve certain witnesses as well as documents for, I understand, for the safety of those witnesses or those documents, will the defense, or at least how many? In ballpark figures, does the defense have in terms of reserved witnesses and reserved documents?
Ballpark figure, I think we have around. I cannot say, I don't want to give a number, but around 30, kasi it's like 5 representatives from an agency, 3 from another agency.
30? Sir,
ganyan.
witness pa lang tong 30 reserve?
But kasi yung reserve naman, hindi naman ibig sabihin, look, I think we have to clarify this.
Yes, you have to. Because as someone who's covering, I'm quite shocked na 30 pa.
Whoever is stated sa pre-trial brief na list of witnesses, including the reserve, it doesn't mean we will be presenting all of them. It also doesn't mean that the prosecution will be presenting all of their witnesses. It will depend on the course of the trial. Ang importante lang, malagay mo doon lahat ng reservations mo at witnesses mo. Kasi pag hindi mo malagay doon, di mo na matatawag.
Yes, because the concern here is parang haba pa.
Yeah, but again, it's nothing different from regular court proceedings. So, but also, alam natin, di dapat natin i-delay unnecessarily itong trial, pero hindi rin natin pwedeng madiliin, no? Because we need to protect the rights of our client, and the prosecution must also be given the leeway to present their case, hindi ba? So pagdating sa mga list of witnesses, both parties, nilagay namin yung list of witnesses sa aming pre-trial brief, pero hindi naman ibig sabihin na automatic lahat yun tatawagin, so na nagbibilang na kagad tayo na, ay nako, kung isang witness ganitong no, it's really not like that, no? So just to clarify, so it will depend on the course of the trial, and I'm sure both parties would like to expedite proceedings as much as we can.
Presiding Officer Cheese Escudero described this week's trial as, he compared it to diesel, saying na medyo matagal siyang uminit sa simula, but as we further on, it gets to somehow get heated up or quicken, hopefully. How would you describe this week's trial? Well,
this week's trial, obviously, people I bet felt that last Tuesday medyo ang haba nung ginawa na direct examination ng prosecution. But to be fair to them, that's normal also, because syempre we need to authenticate documents, no? And when you do that, there are videos, there are documents. It really takes time because you have to go through each document. So, but I agree with, of course, the presiding officer. Not that I have the right to agree or disagree, but I agree naman with his sentiments, because even in the previous trials, because I grew up watching the previous trials, ganoon naman talaga. Medyo sa umpisa, but towards, once the trial really gets going, medyo bumibilis na. Kasi pag sa tingin mo naman, hindi mo na kailangan mag-cross-examine dahil wala namang napatunayan, hindi ka na lang magka-cross-examine, diba? Yung mga ganun bagay. Like, they no longer redirected the other day, so, hindi na na-redirect. Kasi kung nag-redirect sila, magre-recross din kami, di ba? So may mga ganung mga nuances, mga bagay-bagay that I believe both parties really are trying to expedite everything. So hopefully, ano naman.
And before we let you go, I know na you have been monitoring social media, and one of the common criticisms against the defense is that seemingly, allegedly, one of your strategies is to lengthen the proceedings so that public would lose interest in the trial. Your comment?
No, that's totally untrue. That was never even discussed within the defense team. Now, if people think that way, I respect everyone's opinion. It's a free country, and we have that freedom of expression and speech, which I think we have to all respect. So, if that's their opinion, that's okay. But at least on our end, wala kaming napag-uusapan at all about that, because we also don't want to subject the respondent to such a prolonged proceeding. And even as lawyers, syempre gusto na rin namin as much as possible na matapos sa lalong madaling panahon itong impeachment trial, because, and we all know, I was part of the government before. Budget season will be coming up also for the national government, di ba? So sa amin naman, between the prosecution and defense, I don't think any of the parties want to delay this any further than it's supposed to go for.
All right, and we would have to leave it at that and wait and see what happens next. Thank you so much for
Thank you.
making time for.
So, ayan na rinig natin yung mga posibleng mangyari mamaya. Yan ang sinabi ni Attorney Powa, no? Actually, ano lang kung ano ang magiging takbo ng isip ng mga prosecutors, ika-counter nila. Okay? At yung mga nagsasabi na yung kay Zuleika Lopez, yung pagpunta doon, pagpunta kay BP Sara, strategy ba yun? Ayan, nag-over-analyze na yung mga observers at mga kalaban. Okay? Heto po, kilalanin natin ang mga defense team. Ito, grabe, ang galing nitong mga defense team ni BP Sara. Panoorin ninyo.
Mula sa Fortuna, Narvasa and Salazar Law Firm ang karamihan sa mga abogadong mangunguna sa defense team ni Vice President Sara Duterte sa kanyang impeachment trial. Magsisilbing lead defense counsel si Attorney Sheila Sison. Kilala siya bilang isa sa mga pangunahing litigators ng kanilang law firm at may malawak na karanasan sa paghawak ng criminal litigation. Kabilang na ang mga kasong dinidinig sa Sandigan Bayan.
Sa mukha pa lang ni Attorney Sheila, no, para talagang matatakot ka ng debatehin
Kabilang din sa mga mangunguna sa depensa si Attorney Philip Siegfried Fortun, founding partner ng firm. Mahigit 3 dekada na siyang nasa legal profession at nakilala sa paghawak ng iba't ibang high-profile cases. Kabilang dito ang criminal at civil litigation, arbitration, environmental law, corporate rehabilitation at maging mga impeachment proceedings. Kinilala rin siya bilang isa sa top 100 lawyers in the Philippines ng Asia Business Law Journal. Kasama rin si Attorney Gregorio Narvasa II na bukod sa pagiging batikang trial lawyer, aktibo itong nakikibahagi sa mga programa.
Ito mga defense team ni BP Sara, dito sila parang na-intimidate Itong mga prosecutors doon sa house, parang wala sa kalingkingan sila
Para sa judicial at legal reforms. Ilang ulit din siyang kinilala ng Legal 500 Asia Pacific bilang recommended lawyer. Bahagi rin ng defense team sina Attorney Christine Ferrer, isang CPA lawyer na may 15 taong karanasan sa corporate law, taxation at litigation. Attorney Carlo Joaquin Narvasa na nakatuon ang practice sa litigation, arbitration, corporate law at dispute resolution. At Attorney Justin Nicol Bular na may karanasan sa litigation, labor, family law at corporate practice. Kasama rin sa legal team sina Attorney David Ronel Gola II, Attorney Lyndon Miguel Baquel, Attorney Carol Grace Oroseo, Attorney Clarlene Radok, Attorney Francesca Marie Flores at Attorney Miguel Carlos Fernandez na may kani-kaniyang espesyalisasyon sa litigation, corporate law, labor law, taxation, arbitration, immigration at family law. Hindi lamang mula sa Fortun, Narvasa and Salazar Law ang bumubuo sa defense panel. Miyembro rin ng defense team at tumatayong spokesperson si Attorney Michael Wesley Powa. May espesyalisasyon si Powa sa criminal, civil at commercial litigation, taxation at special projects. Nagtapos siya ng Juris Doctor sa University of the Philippines. Top 9 sa kanyang batch noong 2018 at nagsilbi ring Undersecretary.
Ito yung comment ko sa defense team ni BP Sara. Actually, 16 lawyers po ito. So, mabigat. Ang kagandahan dito sa kanila, walang masyadong drama. Hindi nagpapapresscon. Ang spokesperson lang nila ay si Attorney Powa. Okay? Tapos, kapag interviewin naman si Attorney Powa, mamaya ipapakita ko yan. Bitin na bitin yung mga media na magtatanong sa kanya. Very reserved. Okay? Hindi mo talaga, kung kayo yung kalaban dito yung mga prosecutors, hindi mo talaga mababasa ang kanilang move. Talagang grabe ang kanilang depensa talaga, strategy. Doon sa kabila, parang minuminuto nagpapa-press con. Itibag sila talaga. Alam na talaga nila kung paano nila gigibain yung prosecution, di ba?
Chief of Staff at tagapagsalita ng Department of Education mula 2022 hanggang 2024. Kabilang din sa legal team ni VP Sara sina Attorney Mark Binduan na naging miyembro ng Philippine Bar noong 2014 at ang mga abogado mula sa Bodota and Batong Bakal Law Offices na sina Attorney Ralph Borja Bodota, isang CPA lawyer na may karanasan sa litigation, taxation, corporate at commercial law, at Attorney Roberto Narvasa Batong Bakal na nakatuon sa litigation at naging bahagi ng mga kasong nagresulta sa mga landmark decision ng Korte Suprema noong 2025. Mahalagang papel ang gagampanan ng 16-member defense team ni VP Sara para bumuo ng legal strategies upang ipagtanggol ang pangalawang pangulo sa impeachment trial. Dala ng grupo ang magkakaibang karanasan sa litigation, constitutional law, corporate law, taxation at iba pang larangan ng batas para sa paggulong ng paglilitis sa Senate Impeachment Court.